The chair recognizes the gentleman from Arizona, Mr. Franks, for 5 minutes.
Well, thank you, Mr. Chairman. Mr. Chairman, sometimes the track record of a particular witness to obfuscate is so strong that it vitiates the purpose of additional questions. And all that one can do is to state the facts and hope that they will be enough to serve the cause of justice. Commissioner John Koskinen took over the Internal Revenue Service in the wake of the IRS conservative group targeting scandal, ostensibly for the precise purpose of reforming that agency internally. Instead, he pointedly continued his predecessor's legacy of deliberately stonewalling justice. After Lois Lerner, director of the IRS's tax-exempt organizations unit, invoked the Fifth Amendment when she appeared before Congress, the Committee on Oversight and Government Reform issued a subpoena for IRS documents, including all of Lois Lerner's emails. The IRS's Chief Technology Officer specifically issued a preservation order instructing employees not to destroy any emails, backup tapes, or anything relevant to the investigation. But, Mr. Chairman, despite a congressional subpoena and a do-not-destroy order, the IRS Inspector General found that the agency erased 422 backup tapes containing as many as 24,000 emails. Now, I know that's been stated here, but all the while, Commissioner Koskinen knowingly kept Congress in the dark. Commissioner Koskinen was clearly aware that the emails had been lost, but he knowingly and deliberately withheld that information from Congress for 4 months and stonewalled the entire investigation. Mr. Koskinen testified under oath 4 different times before Congress during that 4-month period, saying he would turn over all of Lerner's emails, making no mention of the fact that the bulk of them had already been, quote, lost. Mr. Koskinen provided false testimony and swore under oath that the information on the bulk of the backup tapes was unrecoverable. The Inspector General found that approximately 700 of those emails had not in fact been erased and were in fact recoverable. Commissioner Koskinen then failed to protect citizens against the same type of future discrimination. A General Accounting Office report found no significant measures had been implemented under Mr. Koskinen's watch to ensure that civil servants at the IRS don't continue in the future to unlawfully target Americans based on their political or religious views. Mr. Chairman, this entire matter was absolutely counter to everything a republic like ours was meant to be. In a constitutional republic like the United States of America, we are fundamentally predicated on the rule of law. And there are very few things that more shamefully break faith with America and the American people, or that undermine their trust in their government, more than witnessing those given the sacred responsibility to enforce taxation equally and according to the law, using the federal government's power of taxation and its attending power to unlawfully and economically destroy. For them to then deliberately oppress American citizens based on their religious or political views with these powers is an unconscionable act. And such a tyrannical abuse of power and the betrayal of their sworn oath to the United States Constitution by Mr. Koskinen and Mr. Obama will be writ large in their legacy, because it is something that goes to the very heart of the rule of law in this republic, and that so many lying out in Arlington National Cemetery died to preserve. Mr. Koskinen would never have allowed an American taxpayer to treat an IRS audit the way he and other IRS officials have treated this congressional investigation. The Congress owes it to the American people and future generations, and to our sworn oath to the Constitution, to hold the perpetrators of this tyrannical abuse of power accountable and to make sure it never happens again. And, Mr. Chairman, with that, I yield back.
Chair thanks the gentleman and recognizes the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman. Commissioner Koskinen, since you are the Commissioner of the IRS, I have some tax questions for you. Since 1976, Commissioner, every Democratic and Republican candidate for president, every one, has released his personal tax returns. And releasing tax returns provides voters with important background information on the candidate's contributions to his community, how he may operate his business. And I just would like to confirm a few things that we might know if we had access to the candidate's tax returns. Releasing a tax return can demonstrate how much a person pays in taxes. Is that correct?
You would know anytime anybody filed what they paid in taxes, yes.
And would it also tell us how much a person gives to charity?
To the extent they took the charitable deduction, it would, for various reasons, sometimes people don't.
Would it give us some indication into a person's assets or investments?
Harder, all you report is income and expenses, so it would not necessarily tell you a lot about assets other than that they produced a lot of income.
If they produced a lot of income, we can draw some conclusions about the amount of the assets.
Right, but there would be no way to actually know what the assets were.
And would it confirm how the person has chosen to try to reduce his tax liability?
Yeah, you would be able to see in any taxpayer return what the deductions were, what benefits they took advantage of.
Right. If we had the tax return, would it provide information on how a person receives his income? Right?
You would see the source of income, yes.
Right. And we may, if we had the access to the tax returns, have some indication how the person finances his real estate transactions.
You would have some. You wouldn't have a full picture, again, because you wouldn't have a picture of all the assets.
We'd have some. Right, we'd have some, as opposed to none. Is it correct that a lot of this information we would be able to glean right from the first couple of pages of a person's 1040 and Schedule A?
You would have some, but it would be a very high level of abstraction because there would not be any of the exhibits.
Right. But let me go on. As you're aware, the current Republican nominee for president, Donald Trump, has repeatedly said that he's unable to release his tax returns because he's under audit by the IRS. He said, when the audit is complete, I will release my returns. I don't have a problem with it. It doesn't matter. So I just have a few questions about that. Under current law, the IRS is prohibited from disclosing a person's tax returns, right?
Correct.
But current law doesn't prevent a person from releasing his own tax returns.
That's correct.
And how long can an audit go on?
Audits can go on, depending on the complexity, for years.
And a person's not prohibited from releasing their tax returns while they're under audit, are they?
No, they may be advised not to, but they're not prohibited.
Advised by the IRS not to?
They may be advised by their advisors, but not by the IRS.
Okay. And in fact, Richard Nixon released his tax returns while he was being audited by the IRS. Is there anything in the law that prohibits a person from releasing his tax returns during an audit?
No.
Does the IRS, let me ask another question. Would releasing the person's tax return during the audit in any way impact that pending audit of the return?
The release itself wouldn't. The concern sometimes by taxpayers is that when the information is public, there may be more information that will be discovered or provided.
That is
the release
concern.
Itself.
I understand.
Not.
Right. We understand that's the concern. Does the IRS send a letter to a person informing him that he's being audited by the IRS?
Yes. In other words, in fact, as I tell people with the phone scams, if you're surprised to be hearing from us, you're not hearing from us. We send you a letter if we're going to start.
Commissioner Koskinen, is there any law or regulation that prevents a person from publicly disclosing the letter from the IRS that tells them that they are being audited?
There's no restriction by the IRS.
Releasing tax returns, as we've just been discussing, provides transparency. It's being reported also on the front page of today's Washington Post that the Trump Foundation spent more than $250,000 to settle lawsuits that were filed against his business. Just a few remaining questions there. Is it illegal for the head of a nonprofit to use money from the charity to benefit himself or his business?
As a general matter, nonprofits are not allowed to, it's called inurement, use benefits of the tax-exempt organization for their own purposes.
Is it also illegal for a nonprofit group to make political gifts, such as the Trump Foundation's $25,000 contribution to the Florida Attorney General's reelection campaign?
I can't talk about any individual taxpayer's activities. The law is clear. 501c3 organizations cannot be involved in politics.
Right.
But I, again, would stress we never talk about any individual's tax returns or their policies.
Right. Commissioner Koskinen, we shouldn't have to ask you to talk about Donald Trump's tax returns. We should be free to talk about those tax returns because, as you've told us, there is simply no reason that he has not shared them with us. He's not been prohibited from sharing them with us. And, in fact, there's no rule that says that he can't at least provide the audit notice so that we can have some small piece of information that might help us. You're right. We can't learn everything there is to learn about his finances from his tax return, but it sure would be an important start for the American people, and I appreciate your being here to help clear some of that up, and I yield back the balance of my time.
The chair recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Mr. Koskinen, is the IRS still targeting conservative groups?
Absolutely not.
Mr. Koskinen, that's not what the United States Court of Appeals for the District of Columbia said. They just issued a decision on August 5th, 2016, last month. And I just want to read from that decision. They said, cessation has never occurred. The IRS has admitted to the Inspector General, to the District Court, and to this court that applications for exemption by some plaintiffs have never to this day been processed. That sounds like still going on to me, Mr. Koskinen. Let me just read further.
Okay.
They say it's absurd to suggest that the effect of the IRS's unlawful conduct, which delayed the processing of plaintiffs' applications, has been eradicated when 2 of the plaintiffs' applications remain pending. Sounds like targeting still going on to me. Let me just paraphrase that. It's absurd to say targeting is stopped when the unlawful conduct continues. Again, this is not Jim Jordan saying this. This is not Donald Trump saying this. This is not the Freedom Caucus saying this. This is the United States Court of Appeals for the District of Columbia, decided just 6 weeks ago. So you guys are still up to it, aren't you?
Now, as I wrote in a letter to all of the oversight committees, including yours, there are 3 cases out of the 145 that have not been processed because they're in litigation, and our policy for years has been if you're in a process and then you sue us, we stop the process. But those are 3 from 4 or 5 years ago. They are not new cases. There is no new case in the last
these guys have been waiting 4 or 5, some cases 6 years. And you know, I figured you would say that, and so doesn't carry much weight with me, and it frankly didn't carry any weight with the court. Because here's what the court said to that very argument. They said the IRS is telling applicants in these cases, quote, we've been violating your rights, not processing your applications. You are entitled to have your applications processed, but if you ask for that processing by way of a lawsuit, then you can't have it. So the court wasn't buying your argument. They don't care what your internal policy is. They're more concerned about people's fundamental liberties, and you guys continue to violate them. They go on to say this, we would advise the IRS, if you haven't ceased to violate the rights of the taxpayers, then there is no cessation. So if you're still doing it, if you haven't stopped doing it, then you're still doing it, is what the court said. You can't sit there and say you're not still targeting. So here's what we got to keep in mind.
Targeting is a present tense verb. Those organizations were improperly selected 4 years ago.
These organizations still don't have their tax-exempt status.
And as I noted, once the court made that issue, while we for 50 years have stopped processing, we are processing those applications.
Remember, Mr. Cotton, this is not me making the argument. This is not just all these, we've heard from the other side, these conservatives who want to impeach the IRS commissioner. This is the court saying you guys are still doing it. You're still, and never forget what happened here. Never forget the underlying offense. The IRS targeted people for exercising their most fundamental liberty, their right to speak against the policies of their government, and they got harassed for doing that. We've heard a lot about due process from the other side. I think you should get every bit of due process you're entitled to. But how about the due process that all these people were who got harassed for years, and 3 groups are still getting harassed today? Here's what happened. You guys, the IRS targeted folks, they got caught. Ms. Lerner, at first, she lies about it. She says, oh, it wasn't us, it was those folks in Cincinnati. Then she takes the 5th. That sort of puts a premium on all the documents and communications, making sure we get those. That's why we had 2 subpoenas and 3 preservation orders for that information. You come in to clean up the mess, and under your watch, documents are destroyed, false statements are made, 422 backup tapes are erased, and now the clincher, it's still going on. And so the other side can say we shouldn't be here today, you shouldn't have to sit through this. I'm saying, why haven't we done this a long time ago? You should have been going a long time ago when this is the record. Losing emails, backup tapes destroyed, targeting still continues to this day, not Jim Jordan's words, not Freedom Caucus words, words from the Court of Appeals. For goodness sake, that's why this hearing is important, and that's why we should move forward with the articles that Mr. Chafetz submitted 15 months ago and make sure that you no longer hold office. Mr. Chairman, I yield back.
Chair thanks the gentleman. Recognizes the gentlewoman from California, Ms. Chu, for 5 minutes.
Thank you, Mr. Speaker. Mr. Chair. Commissioner Koskinen, to date, how many investigations have you been involved with regarding the events referenced in this impeachment resolution. Could you explain your personal involvement in each of these investigations?
When I started, and again, all of this happened before me, when I started, there were 6 investigations ongoing. The House Oversight Committee, Ways and Means Committee, the Senate Finance Committee, the Senate Permanent Subcommittee on Investigations, the Department of Justice, and the Inspector General all had investigations going on.
What were the results of these investigations?
The results, as earlier noted, the results were the IG noted in its investigation that no one had done anything purposefully to impede the congressional investigations. Nobody had instructed anybody to do that. The Justice Department said, while there, and I would totally agree, mistakes made, it was not a perfect process by any means. No one had done anything that, in fact, raised to the level of any activity subject to they basically said nobody did anything that impeded the investigation. The bipartisan report from the Senate Finance Committee, again, had all the information they needed, disagreed. There was a majority report and a minority report about whether it was political motivation or whether it, in fact, was just bad management and a poor management judgment. The bipartisan report had a series of recommendations. We accepted all of those recommendations. We actually accepted all the recommendations of the majority report and the minority report. The Permanent Subcommittee on Investigations closed its report. It was the first one, and it basically maintained that there was nothing done that was intentional in terms of any material presentation. Everybody has agreed that it was a management mistake, a terrible mistake. It shouldn't happen again. No one should be selected for any adverse activities, either a denial of a application or wait for time, simply because of the name of the organization. This was not political philosophy. This was, in fact, selecting people only by the name of the organization, and everybody has agreed, and I totally agreed when I started. In fact, I apologize to anyone who was stuck in the process for more than a year waiting for an answer. The Ways and Means Committee has not issued a report. The House Oversight Committee did not issue a committee report. There was a staff report issued at the end of 2014.
In fact, let's talk about the Treasury Inspector General. Could you just describe what the working relationship is like between the staff at the IRS and the Treasury Inspector General? Are the results of the investigation by them generally considered non-biased and reliable?
Yes, for 3 years when I was in OMB, I chaired the Intergovernmental Organization of Inspectors General. I've always been a supporter of the IGs. In the private sector, I was a supporter of internal auditors. I meet with our staff, with the senior staff of the IG every month. As I tell our employees, the IGs and GAO don't create problems. They raise issues before that we might not otherwise know, and it's important to respond positively. And we have responded to the IG's recommendation. The IG reviewed it and said we had actually basically implemented all of their recommendations. They had some additional recommendations. We've implemented those as well. But the IG has done, I think, a good job. I knew him when he's worked on the Hill for the Republicans, but I don't think he has been political. I think he's done a straightforward job, and we have a good relationship.
Mm-hmm. One major problem here stems from the decision of 2 IRS employees in a West Virginia facility to erase the backup tapes that contain some of the Lois Lerner emails. The Inspector General found in its June 2015 report that no evidence was uncovered that any IRS employees had been directed to destroy or hide information from Congress, the DOJ, or the Treasury Inspector General. Let me ask this. Did you make an affirmative order that those tapes be preserved? And did you ever make efforts to keep this information from Congress?
No, I never kept any information from the Congress. As I say, my counsel in February of 2014, within a few weeks of my arrival, sent a reminder to the IT department, making sure that they understood that all the media should be preserved. And again, as I said, when I discovered in 2015 from the IG that those tapes had been erased, I said that was a mistake. It shouldn't have happened. And as has been noted, I run the organization, and if the honest mistake is made on my watch, it's my mistake. I tell employees that.
So you made several statements saying that those tapes should be preserved then? Your office
I did not make several. It had gone through the system. There was a standing order in 2013. There was a reminder that went out from my counsel to the IT department to preserve those reports. We were making a massive effort to production, so you would have thought, everybody would have known that we're producing documents as fast as we could, and therefore we should protect them.
Thank you. I yield back.
Chair thanks the gentlewoman. Recognize the gentleman from Georgia, Mr. Collins, for 5 minutes.
Thank you, Mr. Chairman. Ms. Kosh, thanks for being here. I think it's interesting that we have the Commissioner of the IRS here to give tax advice. I'm glad that you have worked with my office to actually help my constituents actually be able to get tax advice, where we had one person with 700,000+ people having to take golden tickets at a front door at 3:30 in the morning. I know we've added another one. I would like to see another added there, and we still have some ongoing correspondence that I would like some breakdown on the letters that I have shared with you.
And I'm delighted to do that.
And we'll continue. However, let me go back to just a couple, because you and I have had several conversations. This thing has round over several years, and we have had conversations when I was a member of Oversight Committee. And do you believe that, and just from your law, just to settle the same, a subpoena is a valid form of getting information from someone who is being asked for? It's like if the committee actually subpoenas the Treasury or the IRS to produce documents, that's a valid form of getting documents.
It certainly is.
And it is it should be followed, correct?
Yes.
Okay. In September 2014, I asked you, and this is not require a transcript, I'm going to give you your answer back, but it says, I asked if the IRS had produced all the emails from Holly Paz as required by subpoena, this subpoena currently right here, at the Oversight Committee. I'd ask you the same question 56 days earlier, and the answer then was no, and then when I asked you the question in September of 2014, the answer again was no. My question to you today, have those documents been produced to the Oversight Committee?
I don't know. We've been working from the start with the committee staff to prioritize. We had a long hearing, as you'll recall, in March of 2014 about the order in which we would reply to the subpoena. I made it clear we were prepared to respond to the entire subpoena. That's how we ended up with the committee saying their first priority would be all of the remaining Lois Lerner emails, and I said we would provide those. Since then, we've been working with the committee and working our way through the subpoena in terms of whatever information they would want.
Okay. Well, and number 2 on this subpoena, just as the schedule, which was supposed to have been produced on August 16, 2013, a nice day, that was my birthday. It didn't get the gift of being produced, but on Holly Paz was number 2 on the list. Right. And on the actual required. My question is this: Holly Paz is not in a crash situation. Her hard drive was never in doubt. Why the delay here? Are you blaming the committee?
No. We've, as I say, the committee has a vast subpoena they're asking for, some information from 90,000 IRS employees. And at that hearing in March of 2014, we agreed that we would get Lois Lerner emails, and then we would respond to the committee staff as we went forward. We have provided Holly Paz emails. I just can't tell you whether all of the ones from Holly Paz that have anything to do with this issue have been provided. The question is, have we provided other emails that she may have sent? And I don't know the answer to that.
In your legal, in just your opinion as commissioner, do you think that you're in compliance with this subpoena?
I think we are in compliance with that subpoena in terms of our discussions with the staff. We have not completed, as I say, one of those questions is emails from 90,000 employees outside, and I've explained in 2014 that that would take a long time, and in our discussions with the committee staff, we are not pursuing that.
And we've understood that, but some of these were specifically named. The 4 people specifically named were not these vast amounts out here.
Right.
Holly Paz has no constructive problem with a computer. It was a hard drive. You could get it off of it. I know, and it sounds very frankly, and I know this, you're a very good witness in that you parse your words very well. That's a compliment, but it's also the very frustrating part of this whole thing. It sounds very much like you're blaming committee staff on their priorities here. If you just, I think at this point, this is the frustration that we all have with this.
I don't mean to do that, and I apologize if there's any indication that I'm trying to blame the staff. All I'm saying is we've been working with the staff in terms of response to the subpoena to the extent that and as I say, we provided all of the Holly Paz and all of everybody's emails regarding the determination. That's how the 1,300,000 pages came out. About, so I've forgotten how many hundreds of thousands of emails there are. To the extent that the committee at any time feels that there's additional information that we haven't provided, we've been providing information. We sent a note to everybody to say we're done with document production in January 2015. If we haven't provided all of the Holly Paz other emails that have nothing to do really with this, and the committee staff would like those, we will do that.
As I said before then, I'll say again now, this is what the American people just do not understand, the selective ability to, to work with a subpoena or not. And with that, Mr. Chairman, I yield back.
Right.
Chair thanks the gentleman and recognize the gentleman from Illinois, Mr. Gutierrez, for 5 minutes.
Hi. Thank you, Commissioner. So I'm going to finish up this Skittle. I really love Skittles because, as you see, they come orange and yellow, red and purple, all the different colors, and they come all together in a bag, together, right? all different colors and kind of like a rainbow. A lot of people on this side of the aisle, we like that. And every now and then, I'll get a bad Skittle, but I don't ban them all because I get one. Because most of the Skittles are pretty delicious. I like them. They might not be nutritious, but they're delicious. Just like we shouldn't ban all the little girls fleeing murder and rape, and human bondage and torture. We shouldn't ban them all. Just like we wouldn't ban all the Skittles, because there might be one bad Skittle. This is a nation of freedom of religion. And yes, even freedom to pay your taxes to the United States. Commissioner, I have a few extra bags of Skittles, and I'm going to share them with you and your staff so that after this reckless and bitter hearing, you can get a small amount of sweet candy to improve the rest of your day. Now, I have a question. Is it fair to say that you're an expert on tax law at this point?
No, I've never claimed I was an expert on tax law.
Okay. I know you can't answer questions about specific tax returns. You've made that abundantly clear to my friend, Mr. Deutsch, and others as we've had the hearings. Even if those tax returns, everybody in America would love to see them, you can't share them. So we can't do a poll and send it to your commissioner and you can abide by the poll. There's laws. Or to answer specific questions about any individual's tax activity. So I want to offer a hypothetical and see if we can't get your reaction. Let's say someone set up a charitable foundation. Let's say someone solicits millions of dollars for that foundation. And let's say that that individual who set up the foundation used the money from that foundation, which is tax exempt by you at the IRS. This is a tax exempt tax foundation. And he uses it to pay off debts incurred by his for-profit companies. Tax exempt, charitable, use that money to pay off debts incurred. In fact, not only does he do that, he uses to pay off legal judgments against his for-profit company. That's just the company I'm making money from, and I'm hopefully paying you taxes. And I'm using the other money that I don't pay you taxes because it's tax exempt. So let's say for the sake of argument, the individual says he would pay someone $1 million if they hit a hole-in-one during a tournament at his golf course. And after someone hit the hole-in-one, the individual refused to pay. Then after a court rules that he has to pay, $100,000 will be paid mutually agreed by a charity, a part of that settlement. The individual takes the $100,000 of other people's money, not his money. The court said you have to pay the money, individual, but he uses it from the foundation to pay that debt. My question to you is, given that scenario, is that strictly speaking, what's the term, legal to do something like that? I just want to know, would that be legal for an individual to use money from a tax-exempt account, foundation, a charitable account, of other people's money to pay off legal obligations incurred by his for-profit enterprises? And before you answer, let me just follow up. Again, strictly hypothetical. Let's say there were a $10,000 portrait of the individual, and he used the foundation's money to buy it, put it in one of his for-profit businesses, writing a check out of the charity auction drawn on the charity using other people's charitable tax-free donation, but using the portrait in his for-profit business. So I get a bunch of money, I put it in my foundation, we don't pay taxes on it, I go and bid on a portrait of me, and then I put it in my business. Would that, in your opinion, be legal within the law and consistent with someone who declares himself a law and order individual?
Congressman, I said at the start I came here to answer questions truthfully and straightforward, but we don't talk about individual cases, and if hypotheticals begin to look like individual cases, I'm not at liberty to give opinion or judgments about those.
But Commissioner, you do know whether something's legal or not. I mean, here's the question. Can someone take money from a non-for-profit foundation and pay off a legal settlement, court settlement, to pay that debt off?
What I can say
can you use tax-exempt money to pay for business purposes?
as I said before, the law is clear. Any tax-exempt organization cannot use its money to benefit anyone closely associated with that organization. But I can't give you, every case is different. Every case has background and information surrounding it.
Commissioner, you know who I'm talking about. Everybody in this room knows who I'm talking about, right? So all we want is a straight answer, right? I know, can you get a haircut?
The time of the gentleman has expired.
You buy new suits? What can he use with that tax-exempt charitable money?
The time of the gentleman has expired. The commissioner will be allowed to answer the question if he chooses.
As I would stress, I think it's important for all the taxpayers to understand. If you deal with us, your information we go to great lengths to protect. Our employees understand every taxpayer's information is sacrosanct. We do not reveal it to anybody. And it's important for them to understand that we do not discuss anything about their tax situation with the public. And so while I understand the interest in this issue, even in the hypothetical sense, it would be inappropriate for the Commissioner or anybody else at the IRS to respond other than to say the law is clear as to what 501c3s can do and cannot do.
The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Commissioner, I want you and I to do something that those of us who serve in government probably ought to do with a little more regularity, which is put ourselves in the shoes of the people that we purport to work for. I want you to imagine waking up and you learn that agents of an agency that you already fear, one of the most feared agencies in all of government, with a lot of control and power, either real or perceived, over your life. Some agents of that agency are targeting people based on their political ideology. And those are folks in positions of leadership. I don't know if you've read Lois Lerner's emails or not, but there is a palpable animus, a hostility towards conservatives that comes through in her work emails. These are work emails. This is not her musing about an op-ed in the Washington Post. These are work emails demonstrating a tremendous enmity towards conservatives. And some of those groups wanted to do nothing more than just educate their fellow citizens about the Constitution. And so I'm sure you can appreciate the irony of Lois Lerner punishing people who want to educate their fellow citizens about the Constitution, and then she comes and hides behind it to avoid answering questions about her conduct. That's why people are upset. And then you add to that the President of the United States, the person who campaigned as the great uniter, that the same rule should apply to everyone, really didn't mean it after all. And he prejudges an investigation while the investigation is pending. So against this backdrop, Congress, I'm sure you will agree, has not only the right, but frankly an obligation to provide oversight over an agency where that is the prima facie evidence at bar. We have an obligation to do it. But the efficacy of our investigations depends upon the fullness of the information we're provided and the honesty of the witnesses that come before us. We are of no use if we have incomplete information or those that we seek information from are not truthful. So there's a piece of your testimony that has troubled me, and I want us to go through it. And this is what you said. Since the start of this investigation, every email has been preserved. Nothing has been lost. Nothing has been destroyed. So I want us to go through it. What did you mean by since the start of this investigation?
I meant since the response, as you note, the appropriate congressional response to the IG report in May of 2013 when the 6 investigations started. The investigations there, as I said, were 4 congressional, the IG and DOJ.
All right, so you and I are in agreement. You meant from the very inception of the investigation.
Correct.
And then your next, this is under oath. I think you'll agree it's material, it's important. We're not asking you about something unrelated to the investigation. It's under oath. The next thing you say is every email has been preserved. What did you mean by every email?
I meant every email that the IRS had that I knew of had been preserved. That's what I thought. That
Well,
was
then
my
why
honest
didn't you say
belief.
that?
Pardon?
Why didn't you say that?
Well, if I knew then what I know now, I would have testified differently. But at the time, I testified honestly on what I knew and what I had been told.
Well, then
And
that gets us.
nobody regrets more than I do that in some ways this case has been the case that keeps on giving with new information coming out. I wish the information had all been out to begin with.
Well, Commissioner, it is always an option to say, I don't know. Loretta Lynch has made a living answering questions with, I don't know. It is always an option to say, based on what I was told. But you were incredibly definitive. You said, every email has been preserved. And then for those of us who may not have been paying attention, you said nothing has been lost. What did you mean by nothing?
What I meant at that time was I had been advised nothing. But you're exactly right. In retrospect, I would have been better advised to say to the best of my knowledge or on the basis of what I've been told, which was, in fact, the basis of my testimony.
Well, I'm out of time, but this is what I would like you to do, because this is an important matter. I was one of the folks who wanted this hearing. I think this is really important. And you should be able to provide us information, but Congress should have all of that information.
Exactly.
So what I would like for you to do for me is you use the word mistake. That is the lowest level of scienter. There's mistake, there's reckless disregard for the truth, there's a deliberate indifference, and then there's intent. I'd be curious what you think the proper punishment is for each level of that scienter. And the other thing I need you to do is, to the extent you relied upon other people's counsel or what they told you, I need to know who they were. This committee, and I would think you would want us to interview every single witness that has access to information that would be relevant.
I think you have interviewed all of them already.
So you cannot think of a single person that this committee should interview that we have not already interviewed?
As to my knowledge, at this time, you have interviewed the first 50. I don't know the names of all the 50, but the people who advised me throughout this case, you have interviewed.
Would you do me the courtesy of making sure with your lawyer that the record is complete? Because whenever the record is complete, that's when we have to make the decision. And I am giving you the opportunity, under the heading of due process, to make sure that every bit of information you think should be considered is in fact in the hands of this committee.
Well, I would just note, and without going into detail about it, there's a lot of information and misinformation and misinterpretation of it that's in the hands of the committee. And if there were going to be a full hearing, I would have the opportunity to explore that. We would be able to cross-examine witnesses. We would be able to actually provide you not just the allegations being made, but the facts on both sides. Each side would have the opportunity, but the impact of the facts. You should hear from the Inspector General directly. Who did he talk to? Is he still, as he said in his letter, confident that it was an honest mistake by two employees? It was not purposeful. You should
That's
hear,
what I'm asking.
Yeah.
Give me a witness list, because you can't cross-examine them until we have examined them. So
that's correct. I'd be happy to provide you the witnesses and the information that this committee would need to be able to actually proceed accordingly. But as noted, that would be if the committee decided it wanted to go to a full-scale impeachment process, which I understand this is not.
Thank you, Mr. Chairman.
Time of the gentleman has expired. I allowed additional time because that's a good exchange of what needs to happen. The chair recognizes the gentleman from California, Ms. Bass, for 5 minutes.
Thank you, Mr. Chair. Mr. Commissioner, let me begin by joining in with my colleague on the other side of the aisle and thanking you and your staff for being of great assistance to my constituents in Los Angeles. I've had several members of the community that have had some difficult situations, and your staff has been very responsive.
Thank you.
I know when you took over the IRS, one of the reasons why you were asked to fulfill this assignment is because of your history of addressing organizations that were having big challenges. And I wanted to know if you could describe what specific challenges the IRS faced at the time you took over the organization.
When I took over the organization, first we needed to make sure that the situation that led to the improper selection of people just by their names never happened again. And so we've pursued, and we've, as people have made recommendations over which we have control, we've adopted those. We had a substantial challenge when I started with the underfunding of the agency, which still continues in terms of implementing not only the normal tax seasons, but we had the Foreign Account Tax Compliance Act, we had the Affordable Care Act. Since then, we've had the ABLE Act, we've had the Health Coverage Tax Credit Act, we've had private debt collection requirements, all of which have been basically unfunded mandates that the IRS has had to implement. We are under constant attack by organized criminals around the world trying to get access to our information. So our cybersecurity issues and our antiquated IT systems are a major concern and a major attack for us.
So, go ahead.
And the last thing is, we provide tax credits pursuant to statute, particularly with the Earned Income Tax Credit. And I've been concerned from the start that we need to do everything we can to get the level of improper payments down, make sure everybody eligible participates, but make sure that the right amounts go out. And it's been a very complicated challenge.
So with all of those challenges, it's my understanding that the IRS has spent about $20 million and devoted over 160,000 hours to collect, review, and produce over 1.3 million pages of documents to Congress. With all of that effort, all of that time, and all of those pages, were these primarily related to the 501c3-4 issue?
These were all related to the 6 investigations.
So how, and are those numbers accurate?
Pardon?
Or are those numbers accurate in terms of the amount of money,
Yes, those are the numbers.
time,
Basically,
and
it's
pages?
$20 million. We've had 250 people at various times working either full-time or part-time, doing our best to respond as quickly as we could to congressional requests.
So how did all of that time and money assist the IRS in addressing the number of challenges that you laid out?
The best it was going to do, and I hoped it would do in some ways better than it has, would be to try to assure people that we understood the nature of the problem, which the IG had reported on 6 months before I started, and then we would have a basis for trying to solve that problem. And I think we've done, taken all the recommendations anybody's had, because I think it's critical, going back to the issue about confidence in the IRS and in the government, for people, as I said, to believe that they're going to get treated fairly. We don't care whether they belong to one party or another, whether they go to church, they don't go to church, who they voted for, what their political beliefs are. They should be treated the same way as anyone else, and all of that background is not relevant to us at all.
You know, when the whole controversy was taking place, I found it interesting, the concern over conservative organizations, because I'm very familiar with a number of liberal organizations that felt they received extra scrutiny beyond what was appropriate by the IRS. One of the root problems here in general is the time it takes for the agency to process applications for tax-exempt status. And I know in recent years, especially after Citizens United, the agency was overwhelmed by applications for C3 and C4 status. I wanted to know how you've addressed this problem, and is there currently a backlog?
Presently, there is no backlog. For a C4 application, it now takes an average of 83 days to go through. For C3s, where we had a backlog of 65,000 applications when I started, we've streamlined the process for small charity applications and allowed them to get through in a matter of weeks rather than 9 to 12 months. And there is no backlog. Our goal is for the complicated C3s to get them out within 270 days, and we meet that. For C4s, most of them get handled very quickly and under expedited processing, so there are no backlogs.
And are you still getting a flood of applications, and can you give an example of how things were streamlined?
At this point, we have about 1.5 million subchapter C organizations, tax-exempt organizations. 75% of them are C3, only about 5% are C4s, and the majority of the C4s are garden clubs, Kiwanis clubs, local groups. But every year we get a couple thousand C4 applications, and as I say, the average time for processing now is 83 days.
Thank you. My time is up.
Chair thanks the gentlewoman. Recognize